Okay, whoa. You know, I went to law school because I'm technology challenged. Okay, well, thank you for inviting me again. I'm glad to be here. I'm going to talk about zoning enforcement and enforcement of other codes. And as we go along, if you have questions, I invite you to ask. Of course, you can wait till the end if you want to. But what I'm hoping to do is share with you some things that I've learned so that you can do what you do more effectively. So I'm just going to run through a few things right here at the beginning. I'm sure you've seen this sort of thing. I've got one near my house. It's been there for 8 years, and I keep thinking, why don't they tear the darn thing down? I don't know the answer, but it's sure unattractive and a blight on the neighborhood. I sure wouldn't want to live right next to it if I had my house up for sale. You know, a little bit of commercial activity. Parts available at very low cost. Used tires and tube. And we had, and when I was with Provo, I was the city planner with Provo for 11 years and then went to law school and I was the attorney there for the council for 14 years. And we had a lady that had a situation like this. And the sad thing was, it wasn't just one time that we cleaned it up. One time they hauled out 10 dumpster loads of stuff. And within a few years, it was a few more. And unfortunately, she had other challenges which caused her to do this. I think we call them hoarders now. And of course, the proliferation of signs. I mean, you can think of any number of kinds of problems that we face. And I'd like to ask, how many of you have a zoning or other enforcement program active? And how many of you do it by complaint only? Wow, that's I'd say half. And others of you have another system? Just not, I'm not sure how to, Johnny's covering his eyes. Here's another one. Big trucks in the neighborhood. Some cities have rules about this. Well, why do we do enforcement? We go through this long process. Sherry talked about it a little bit, of establishing plans. We adopt ordinances to implement those plans. We adopt budgets to implement those plans. Presumably those plans reflect what it is we'd like to accomplish. So the zoning code, ideally, is a reflection of what your plan is aspiring to. Although that's not always the case, but it ought to be. We ought to be improving neighborhood quality, at least over time. Sometimes it takes a long time to get things done. But if we have a plan or a vision in front of us and a definite path to the end goal, we can get there. Otherwise, a lot of times we end up treading water. As I mentioned, we want to maintain property values because if we have some of the situations that I showed pictures of a minute ago or others, it can affect the community. A really worst case scenario right now in our country is the city of Detroit. I don't know how many of you kept up on how many thousands of homes have been abandoned in that community. And I mean, it's not all due to zoning enforcement or lack of enforcement. There's a lot of factors there. I'll tell you about one community that was afraid of becoming like Detroit, and they took some very strong action. So how can we improve our zoning enforcement? That's what I'm here to talk about. Number one, clean up the code. I've been amazed as I've worked with various cities over the years that there really, in most local governments, there's no one person or office that's responsible to see that the code is up to date and makes sense. When we have a problem, which usually something we discover kind of by accident, in my judgment, we say, oh, we didn't know that provision was in there. You talk to a department head. Do they know what's in the code? Sometimes they do. I say oftentimes it's not something they focus on. I'd advocate the proposition that you ought to focus on your code and make sure that it reflects your current practices and your current goals policy-wise. A lot of times our codes are not very well written. They're getting better. There's a plain English movement that has taken hold in many places, where we try to write things in a way that the average individual can understand. Let's read this third bullet here. This is from a Utah code. This is amazing to me. Any use of property that may endanger health, safety, life, or property, or cause any hurt, harm, inconvenience, discomfort, damage, or injury to one or more persons shall be prohibited. Wow. That's pretty strong stuff. And I think it would be extremely difficult to prove that there was a violation. It's going to take a boatload of fact-finding to show a violation, because there's really not here a clear standard. And in my mind, it's an overreaching standard, probably. So I don't know if any of you have language like this in your codes, but you might think about it. Here's another one from the Salt Lake City Code that ought to be taken out. It's really, you can tell it's old. It's unlawful for the owner or occupant of any brewery, distillery, tannery, livery stable, barn, or laundry, or factory of any kind to place or premises to permit the same to become noisome, foul, or offensive. Okay, maybe that had some juice at one point in time, but it's obviously old language, and we don't have livery stables anymore, for heaven's sakes. It ought to be removed. But we don't, unfortunately, have a program to actively go through the code and take out problem things. We take care of them periodically, but codes kind of grow like topsy, a little bit at a time. You're blessed if you've got someone who's worrying about what it's like at the end of the day. Number 2, communicate expectations clearly to the citizens. What is it that you want to do? Communicate that you're going to treat them fairly and objectively. Create a predictable path to problem resolution. I worked for one local government where our policy was, we called it letter 1, letter 2, letter 3. You get a complaint, and letter 1 would go out and say, please fix this. If they didn't respond, we'd send letter 2 and say, please fix this, we really mean it, and if you don't, we'll send you to the city attorney's office. And letter 3 was a letter from the attorney's office that said, if you don't fix it, we'll sue you. And sometimes people responded to those things. I operate from the premise that if people understand the rules, most of the time they will voluntarily comply. There's a little saying that has had a lot of meaning to me over the years, and it goes like this. How do you get rid of a bad law? Enforce it. If you have a bad law and you begin to enforce it, your community will tell you pretty quickly, that's a bad law, and you need to change it. What happens most of the time is we just stop enforcing it, but the law remains on the books. That's a problem. Use fines and penalties as a last resort. What we really want to achieve is compliance. We don't want to have this be a revenue generator for the city. That's not the purpose of enforcement. As I mentioned earlier, the purpose is to achieve the community goals articulated in our plans, in our ordinances. And last, we need to have a database of enforcement violations, code violations, that we can manage in a reasonable way. Now this, you can't read this very well on your handout, and I apologize, but if you really want to go get this, you can go to the City of Lehi's website, and this is posted there, and they have this is a brochure that they hand out, and it's also posted. And this is a list of their top 12 code violations in the city. And I'll just run through the headers because you can't read them. Number 1, junk, trash, and debris, inoperable vehicles, overgrown conditions, improper use of commercial vehicles, fence violations, window violations, improper storage of vehicle parts, outside storage. Next page, sign violations, improper use of the zone, or a use that's not permitted by the zone, a right-of-way obstruction, and working without permits. Now, underneath each one of these they have a little description about what the rule is and what the city expects. And again, if you buy the premise as I do, that citizens will comply, most of them, if they know what the rules are, this is sort of a very elementary first step. But it's amazing, I believe, how many cities really do not affirmatively, proactively tell their citizens, here's the problems that we're experiencing, here's our standards, and here's what we would like you to do. And we hope you will do it because you're a good citizen and want to be a good neighbor. So they give some information about how to contact the city. Number 3, change your enforcement approach. I asked how many of you do this by complaint, and I think that is the traditional method. And when people complain too much about our enforcement, as I mentioned, we will consider a change to the rules. And that's the traditional path. One community decided to identify what the source of most of their complaints were. And they found that a certain type or a few categories of complaints took up 90% of their staff time. So they decided, well, maybe we need to either change the rules or we need to do a better job of enforcing those, assuming we want those rules to remain. Some cities take a much more proactive stance in coordinating with other agencies. Some do not. I mean, that's a decision you'll have to make as an entity, as a county. Do you want to be in the business of coordinating with the federal government on wetland regulations, for instance? Or just say that's their rule, they're going to enforce it, we're not going to deal with it. Once you've decided what it is you're going to do, I'm suggesting you have what's called an all-eyes approach. People from every department, or some people from each department, have a responsibility to enforce predominantly certain things. But I can't tell you how many times people will drive by a violation, and let's say it's a illegally parked vehicle or weeds and debris on a lot, and we'll just all drive by. And we know it's there, but we won't do anything because we haven't received a complaint. Well, the citizens quickly become attuned to the idea that the government really isn't interested in enforcing weed control, and it's fine to let my weeds grow. They're not going to do anything to me. Maybe when they get 4 feet high and the neighbor complains, then maybe they'll do something to me. So if you have an all-eyes approach, you can identify a certain class or category of things that you are going to enforce regardless. Now, I dare say most of you enforce the building code. When you see a violation and it's brought to your attention, I believe, am I wrong? You don't, you just stand aside and ignore a known building code violation? Probably not. We have pretty well-organized functions to enforce the building code. That's why we hire a chief building inspector and other staff. I will submit to you that I think if you go to an all-eyes approach and away from a complaint-based approach, the citizenry will realize, number one, that you're serious about enforcement, not that you're overzealous, but you will enforce things in due course and with a fair process, and I'll talk about that in a minute. It's not going to be based on politics. It's not going to be based on who's complaining. Now, again, I'll relate to my own experience, and I assume many of you have had the same experience, but it's amazing what the entry-level job of many planners is. It's at the enforcement counter. That's where they start. They learn the code, and nobody really wants to go out into the field and do zoning enforcement. That's something they want to escape from, isn't it? They want to move up the ranks into management. Why do we put those guys in that position? I mean, they're the least experienced. I'll let you chew on that one for a second and wonder why we do that. Many times when I was in an enforcement mode, and I started in Norwalk, California, and I got into my little Ford Pinto, the gutless thing that it was, and drove around the neighborhood and would do inspections and write it up and turn the paper in, and occasionally the word would come down that Mrs. So-and-so had called the mayor's office complaining about our enforcement. Do sometimes things happen when their political approach is applied? Yeah, it does. Should it? Again, I'll leave you to answer that question. Too much politics in the enforcement regime yields inequities. Although, if it's a bad law, maybe it ought to be repealed. So there's some interplay there. I'm raising some questions for you to think about as well as telling you what some options are. Now here's the main part of what I want to talk about is an administrative enforcement program. It's primarily based on civil, not criminal standards. However, most of our ordinances criminalize violations, meaning you can go to jail or you can be charged a big fine if you're convicted of the violation. On the other hand, a civil process is much less rigorous in terms of legal standards, and I'll show you a chart here in a second. Civil enforcement ordinance provides detailed processes for how the system works. It lays out the job of all the players and how the paperwork should work. And if your ordinance is clear, then you'll have a fair process just by following the ordinance. The ordinance also can consolidate types of violations. I'm working on a project in Salt Lake on this issue, and we went through our code to identify all the different enforcement language in the code and all the different entities and offices that had obligations of enforcement. And we had that much paper when we printed it out. With lots of different processes, lots of different standards. Many of them, I'd say, were written at the time for a specific situation without regard to other situations that might be similar. I think there's a good argument to be made for consolidating all your enforcement activity and all your violations into a few kinds of categories. So you get even-handed treatment and even-handed enforcement. Here's a chart that illustrates the difference between the legal and the civil standards of proof. In a criminal proceeding, it's very formal in court. Civil proceedings are less formal. The burden of proof, this is the real hard one. In a criminal case, it's beyond a reasonable doubt. That's a lot of evidence that the government has to produce to get a conviction. In order to prevail, if you're the government, in a civil suit and a civil enforcement matter, it's simply a preponderance of the evidence. That means that a preponderance means it's more likely than not that X is true. And one court defined it as more than a scintilla, but it's less than 51%. So the preponderance is not very high. Sometimes people think of it as more likely than not as 50% of the evidence. You can think of it in different ways, but it's clearly a lot lower standard than a criminal standard. Similarly, the rules by which the court acts in a criminal proceeding are very detailed and very formal, and we have adopted formal rules, criminal rules of evidence and procedure. In a civil proceeding, all you need to do is provide people due process, which means a fair process, reasonable notice of what's going to be happening, reasonable standards by which the judgments are made. In other words, not arbitrary and capricious. Arbitrary and capricious is one side of the coin, reasonableness is the other side of the coin. If you're reasonable in your process, your procedures, someone complains, you'll prevail. What that implies is that mistakes can be made as long as some mistakes could be fatal, but as long as you're attempting to provide a fair process, some mistakes can be made and it won't be fatal as long as the party wasn't prejudiced by the mistake. The Springville Citizens case a few years ago taught us that. There was a mistake made in terms of procedure, but the court said, even though the mistake was made, it did not unfairly prejudice the persons that were complaining, so no harm, no foul. Fact finder in a criminal case is judge or jury. And the civil side, it's a hearing officer. The hearing officer could be someone you hire. It could be someone on the staff that you appoint. I think there's a lot of sense to appointing someone because they can become familiar with the rules. On the other hand, if you want to use a staff person, that can be done as well. There's both models out there. Abatement orders are possible under the civil side, not possible under the criminal side. It's also quicker. Now let me make a comment about the appeal. This is where civil enforcement really makes a lot of sense from a government perspective. Perhaps on the citizen side it can be seen as perhaps unduly harsh, but it's what the rules now say. Under the administrative enforcement program, it's all civil up to a point. You've got a handout in front of you, this blue chart right here. You'll notice, and I'll come back to my point here in a second after we go through this chart. So, you've got two paths on this chart. On one side is a notice of violation. On the other side is an administrative citation. A notice of violation is nothing more than a formal procedure to tell somebody, you violated the code and we would like you to fix it. Here's the standard, here's the procedure that we need you to go through to complete it. If they disagree, they can request a hearing before your hearing officer or your administrative law judge. The administrative law judge will hear the hearing and issue an order. Of course, if the government's wrong, it's over. But if the government's right in saying you violated it, then the order applies. There's a procedure in there called a default hearing. So if the person doesn't show up to the hearing or doesn't respond to the complaint, then you have a hearing to determine what happens next and to issue the citation. You can see the failure to comply with the NOV, the notice of violation. And then you have the default hearing. The individual could also request a hearing. If they don't comply, then a citation is issued and go down the other half. At that point, fees and costs are assessed. There's no civil fee associated with a notice of violation. So we're not doing this to collect money. We're not even collecting the money to pay for our process on the notice of violation side. We're doing that on the government's nickel. Once the administrative citation is issued, then the ordinances generally say the violator, the responsible person, is obligated to pay the costs to process that. Some people complain that that can get really expensive pretty quickly, but legally speaking, governments can charge the fees necessary to recover their costs. You have to demonstrate that, in fact, you did incur that cost and do a study to justify the fee. But once you've done that, you can recover those costs. If a person comes in and says, I agree, I violated the ordinance, and I will comply in 30 days, whatever you give him. Okay? So he signs a paper and says, I agree, I need to cut the weeds, and I have them down in 30 days. What happens if he fails to do that? If he fails to comply with the administrative enforcement order, at that point, the violation becomes a criminal violation, not a civil violation. In my mind, that's important, because once it's criminal, that will allow you to go to the justice court instead of the district court. The justice courts are faster, and they handle criminal matters. Now that comes back to the appeal question on my earlier chart. If there's substantial evidence on the record to show that the violation in fact occurred, it's going to be an on-the-record review by the justice court to determine was the evidence sufficient or not. If the answer is yes, the violation is sustained. The guy has one appeal to the district court. And the district court will then hear the case and decide whether the justice court was correct or not. A further appeal is only possible if the violator claims that there's a constitutional rule that's been violated in the process. That's very hard to do. I think at the end of my presentation under resources, I listed a case. It's the it's Pleasant Grove v. Orbis. That one discusses what it takes to prevail in district court on an appeal. You don't get any further right to go to the Court of Appeals or the Utah Supreme Court unless there is a constitutional violation, and that's codified in 78A7118 of the Utah Code, sub 9. It says the decision of the district court is final and that may not be appealed unless the district court rules on the constitutionality of a statute or ordinance. In the Orbis case, the guy attempted to argue that there was a constitutional issue, but in the case of lawyering that was less than stellar, apparently, they didn't make the proper argument and the court rejected the claims. So that, in my mind, that's what makes the administrative enforcement program so efficient, is because it's civil up until the point there's a non-compliance. And the guy has agreed under the ordinance, he's agreed in writing to comply. If he doesn't comply, it's a criminal violation. Now that doesn't include the category of cases where a person doesn't even show up and there's a default hearing. But even so, the violation or the failure to comply becomes a criminal violation. So, any questions about that? I hope that's clear. I think that is the crux of the administrative enforcement program, is who hears the appeal, and the fact that it normally 98% of the time is going to stop at the district court level on appeal from the justice court. Now this one is also a little difficult to read. But this is from the City of San Bruno's Strategic Enforcement Guide. Again, that's listed on the last page. You can Google this and you can get this document. I have a copy, and it's about 60 pages, 70 pages. And what San Bruno, California did is they took all their violations and all their code provisions and collapsed them into a few categories. And so here, for instance, we have building code violations, all by type. Here, housing code, municipal code, nuisance violations, and zoning violations, and they've categorized them. For instance, there's fence height, there's illegal occupancy, etc. So they've identified them. The next thing that they've done is try to help people understand what it is they've got to do. And in order to assure that it's done on a equitable and objective basis, they have identified with each violation a little process that needs to be followed. We talked about this one. This is an animal control resolution plan. They call them resolution plans. And that's the guts of this document. There's probably 40 pages of resolution plans by type. And I just picked out a couple here to show you. So what it says is, it cites the code, and it says, within 72 hours of receiving a notice of violation, the violator needs to find a home for the animals or schedule a meeting with a code enforcement officer to determine whether the animals can be kept in their current location. So you've got to go talk to the government. No violations, this payment. No violation is required, or no payment is required if the violation is corrected in 10 days. So you can pick whatever number of days you want. After 10 days, if you elect to apply for a permit to keep the animals, you have to submit an application to the city. And then it says the city will decide whether your application is approved or not in 15 days. An application fee is required. Then 30 days after that, if the permit is denied, the animal has to go. At the bottom, it says, if the applicant does not follow all steps within this time frame, citations will be issued and the city will proceed with an enforcement schedule. Please sign below to signify your acceptance of this timeline. Okay? Evidence that shows the individual knew what the process was and what the expectations were that the government had. If they don't sign it, then of course you have another issue. But I'd say most people will because they want to comply. Here's another one. This is a business license violation. No business license. So again, they say within 72 hours you've got to talk to us. You've got to apply within 30 days and get an inspection from the building office and the zoning office within 30 days to show us that you've complied. This was a simple one. Some of the other ones have 2 or 3 pages of steps involving taking out of the building permit or what have you. But what I'm attempting to illustrate is the government has gone to the process of saying with each violation type, here's the steps that we expect you to go through, and they're backed up by the ordinance. The other thing they put in here in their book is a typical enforcement schedule. Again, so the public can understand how does this process unfold? What happens? It's not just based on my phone calls. It's based on an established routine which is objectively applied regardless of who the violator is. So, I'll just read these, and again, you can perhaps read them on your handout. They have the complaint, they create a case file, they have a notice of violation, then they issue a citation all within a certain number of days. These are all sequential. Then a certain number of days goes by, there's another citation. Then they have the letter from the attorney. Letter 1, letter 2, letter 3, the same thing but with a little more embellishment. The next one is notice is recorded. That's another thing that the administrative enforcement program does is if people do not comply, it authorizes the government to file a notice on the public record in the recorder's office that says this property is in non-compliance and here's what we expect to happen. It may be that you won't get any results until that property is sold, but it puts any stranger to the property on notice of what the violation is and that they need to take steps accordingly to protect their interest if they're thinking about buying a particular property. Once a violation is proven and it's been to court, if it's been to court, then the government can file other kinds of things to collect the judgment in these ordinances, even a writ of execution or a writ of garnishment of wages. Now, if you don't want to have that, you don't need to put it in there, but most of the ordinances basically say we can engage or undertake any legal remedy to enforce a judgment. Okay. Here's the one that I mentioned about earlier. This is from Del City, Oklahoma. And they created a housing inspection program. And they were afraid of becoming like Detroit, from what I have read. It's a small city. I think most of the housing is like what I would call World War II housing, like the little town where I grew up in LA County. It was all built after World War II, and they were most of them 800 900 square foot houses, no basements. This is my house. My dad put a bedroom and a bathroom on the back, and the whole neighborhood was full of them. Well, those are small houses, and people get stuff. And it's easy to have zoning violations in small homes like that because you don't have the parking and you don't have storage and you don't have the bedrooms and any number of other things. What was happening in Del, Oklahoma was that the violations would occur and loans were taken out on the property and over time there was no fixing and the properties would be flipped with continuing violations. And the new property owner would get the property and basically rent it. And so they had a lot of rentals with a lot of degraded housing. So what they said was, it's unlawful to occupy or cause to be occupied a residential structure without a certificate of occupancy. And it was also unlawful for a utility provider, and in this case, the city was also a utility provider, to hook up the utility services unless a certificate of occupancy had been issued. They also said you can only take out utility service in the name of the occupant, primary occupant of the structure. And they decided they were going to inspect everything in town, not just rentals. So this started in 2008. They have made a big dent in their problem. They have been able to get a lot of compliance on life safety problems. This is admittedly a very strong approach. Not every community is going to need this, but the point is they analyzed where their problems were, and they could see that a particular kind of scenario was being repeated over and over, and they took affirmative steps to design a program to address the particular problem that they had, and they laid it out in a very fair and objective way. They are basing their standards on the 2003 International Property Maintenance Code, and there's a checklist there. I would say most jurisdictions have adopted these sorts of standardized codes. Okay, the next thing you can do, you can help connect citizens with the resources that can help them. Admittedly, there's always some category of people who don't have the capacity to deal with their issues. They're elderly, maybe they're ill, maybe they're very poor. Who knows what their problem may be. Some cities have affirmatively identified community groups that are in a position to help someone solve these sorts of problems. And the government takes steps to connect the violators with people who can help them solve their problem. You've got a hoarder, she's mentally ill, she needs some treatment. We can line you up with a provider that can provide you some social services and some treatment that you might not otherwise be aware of. Salt Lake City started providing some mental health number professionals in the city library and nearby, because we have homeless that hang out downtown and they go to the library every day. It's become an issue for some people about whether they want to go to the library because of certain kinds of people who tend to frequent the premises. It's hard for a mom to bring her little kids and feel comfortable sometimes. So the city has taken affirmative steps besides to help the people who are there solve their problems by providing professional help and making it available or connecting them with people who can make it available. Another thing you can do is target particular areas. Oakland, California took all their CDBG money for 1 year and they put it into a 4-block area. It was a problem area. They decided they were going to focus on this and then go from there. You are limited, we all are limited in our resources, so a targeted approach can work. You can work with private groups who are willing to take and do service. Provo had a program and still has a program called Paint Your Heart Out. Volunteers would paint the homes of oftentimes elderly people who did not have the money or the capacity to take care of their home. People would go in over a weekend and it would be painted, whatever was needed. All the paint was donated, all the labor was donated. Made a big difference in the neighborhood. Made people feel better about the neighborhood. It made the individual who received the service feel better about their community. Some cities have had low cost or free trash pickup days or extra days. Maybe put out some bins. Now that can get expensive, but I guess I would ask you, is it more expensive to do the enforcement to get people to clean up, or is it more expensive or less expensive to put out a dumpster once a year and anybody can put anything in there and we'll haul it away for free? Those are judgments you'll have to make, but some cities have done that. Helps people do things, take care of stuff that they aren't otherwise going to do necessarily. Okay, the next thing is you can avoid claims of selective enforcement, although you'll hear them. I don't think it's something you need to worry about if you have a fair process and you have objective standards. Under this case, again, Provo City case from 2006, this is a criminal case. The court said prosecutors have broad discretion to prosecute charges. You cannot base the charges on something that's unconstitutional. In this case, it was a race classification that was allegedly being used as a reason to prosecute the guy. He claimed, if you're suing me because I'm, for example, from Japan, you couldn't use that as a basis for enforcement. But that is a very a high hurdle for someone who's claiming discrimination to prove. To establish a prima facie case of selective prosecution, the defendant must demonstrate that the prosecutorial policy results in a discriminatory effect based on an unlawful classification, here based on discrimination, based on race. To show discriminatory effect, the defendant must make a credible showing that similarly situated individuals of a different race were not prosecuted. Okay, so it's possible, but it's a challenge. That's criminal. Here's civil. To prove a claim of selective enforcement, the defendant must demonstrate in part that there is an intentional and deliberate plan on the part of state officials to enforce the law selectively against them. You remember the Olech case? I think it was in Illinois, O-L-E-C-H. It was a similar type of case. In that case, the government apparently was singling out an individual for harsh treatment by the government. But if you have a fair process that's written down in your ordinance, fairly administered with objective standards, you're going to have to pick and choose where you enforce, and I do not believe you'll need to worry about losing any selective enforcement claims if you do that. Okay, you need to be prepared to address complaints. If you go to an all-eyes approach, and not just complaints, somebody's going to say you're doing this just to generate the money. That's where the notice of violation procedure comes into play, because in that case, as I explained, you're simply advising people what's expected and giving them an opportunity to correct it, no charge to the individual. You can also create a sliding scale of fees, civil fees or fines, technically they're called civil fees, based on the seriousness of the violation. Again, I think it's helpful to categorize the kinds of problems that you have, identify your civil fees or your fine schedule accordingly, and then most ordinances will have kind of a ramp-up procedure that if it's the first time you ever violated it, $100. If it's the second time in 30 days, $200. If it's the third time in 3 months, $1,000. I mean, you can have a sliding scale based on the circumstances and whether or not the individual has repeatedly violated the code. Non-conforming use claims. Sometimes people will say that what they're doing in a land use context is grandfathered. You've heard that. My suggestion is that if that happens, then you should not handle that within the enforcement process, but you should have a separate process for determining whether a non-conforming use is in fact justified. You can look at the Provo City Code in Title 14 under the non-conforming use section. Also, and I'll give you another citation, and it's Chapter 6.26 on apartments. We put in, when I was there, procedure for determining whether or not a basement apartment was a legal use, and it had all the steps we went through to make that determination. Very fair, very objective, and very transparent. I mentioned before, you can have some complaints that this is hard on the elderly or people who are disabled. One that I've heard a lot about this last year is snow shoveling rules. Our city adopted rules that say you've got to clean off the sidewalk within X number of hours after the snow stops. And inevitably, there's some people who don't have the capacity to do that. The city has found other helpers who can take care of it. There is some debate about whether or not the city should go in and take care of those things on their nickel. Again, that's a judgment that each entity has to decide. but there are ways to solve that problem. Another one is, what's your own property look like? It's funny how once government becomes a property owner, it behaves like most other property owners. Doesn't mow the lawn every day or every week like they should. Or doesn't cut the weeds like they're expecting everyone else to do. So local government or government-owned property ought to be the best example of your rules. And if it's too hard for you to go cut the weeds twice every summer, then why in the heck are you expecting everybody else to be doing that? There's another thing I found very useful over the years. Regular reports to the legislative body. Because you know what? Otherwise, they hear about the tough cases. People are complaining, and they think that the whole world is a tough case. They don't realize that 98% of the cases are being handled and being closed on a regular basis. They think that the tough case represents the way you do business. That if you report quarterly or monthly or some regular time, how many cases have been opened, how many cases have been closed this reporting period, how many cases have been open longer than a certain time? Let's just pick arbitrarily, longer than 6 months. That means it's a hard case. What's the status of the top 10 toughest cases you have? Now, this could be a confidential report where the attorney's office sends the counsel an attorney-client privileged communication that says, here's where we are, here's our strategy, we've been to court 10 times and the court continued it for the umpteenth time. I can think of a particular case that I'm aware of that's probably 7 or 8 years old. Very frustrating. It takes a long time sometimes to pursue these cases. Maybe they need to be settled. But if you report what's going on to your legislators, they can in turn speak intelligently and accurately to their constituents about what's going on. Otherwise, you're dealing in rumor, sometimes assumptions that can be incorrect. The other big advantage of reporting is government transparency. The citizens know that this government is serious about enforcing it. Again, it's not an overzealous program, because everyone will have to decide to what degree you're willing to do this, or any level of enforcement. But once you've decided, then the citizens know this is happening on a regular basis. It's very objective. And you'll make believers out of people who might otherwise tend to blow you off. I mean, I hear regularly people who say, don't worry about it. They're not going to do anything. Just do it. You don't need to get a building permit. Just do it. Forgiveness is easier than permission. Right? We've heard that one. Cost recovery, I've kind of mentioned that as well. You can make responsible people pay for or be responsible for the cost of enforcement. At what point you begin to make them responsible, you can decide. You want to charge them on day one, I suppose you can do that. But my view would be to not have the heavy hand of government coming down right at the beginning. Give people an opportunity to get right with the government, help them understand the rules. Okay, I mentioned these other things. One other one. Use separate fund accounting. Create an abatement fund. Abatement is a certain procedure under the Utah Code. I haven't dealt with that too much, but if you're going to do abatement, you'd be well advised to check with the attorney's office to make sure you follow the appropriate procedure for abatement. And many things can be abated, meaning the government, if the individual doesn't clean it up, the government can go clean it up or take care of it and charge the individual for the cost of the service and recover it via court action or a lien or something of that nature. Okay, and here's the resources. I mentioned a few of these things. These cities have, that I've listed here, Midvale, Provost, and the county, Summit County, and West Valley City, have administrative enforcement program ordinances. They're all pretty much identical, but not absolutely identical. If you're inclined to do something like this, I would not adopt it without having your attorney review it and understand it and make sure that it makes sense and it's appropriate. But these are good models to begin from. And then the case law talks about some of the principles that I mentioned. So with that, Johnny, I think we're done unless anyone has questions you want to now ask. Okay. Thank you all very much.